My bill specifically provides that unborn children at every stage of development enjoy all of the rights, privileges, and immunities available to other persons, citizens, and residents of the Commonwealth of Virginia, subject to the laws and Constitution of the United States, the laws and Constitution of Virginia, and the appellate courts of Virginia and the United States as well. What this bill does is create legal status for the unborn, acknowledging that life gives conception. What it does not do is overturn Roe v. Wade or create any criminal statute deriving from any kind of act from a child. It does create legal status for the purposes of wrongful death in cases of negligence regarding the unborn.
Thank you. Let the chair pause just a second. Typically, when we get into bills that deal with this particular subject area, sometimes emotions run very high. We understand that people have very distinct feelings and impressions about this bill. We want to provide a wholesome atmosphere in this subcommittee for those differences of opinions to be expressed. The chair will not tolerate from any party, committee members or audience, any deviation from the decorum and the way we like to operate here. The guidelines we adopted earlier that was put before this committee from the chair. So any questions to the patron concerning Senate Bill 1378? Senator Sassler.
Bill, who would file a wrongful act? Let's say the woman's pregnant and she drinks, she takes drugs, she does all the wrong things. Who files a wrongful action as a result of a miscarriage?
Absolutely. In a wrongful death situation, the wrongful death putative claim would belong to the parent. So in that situation, we're not talking about, you draw the line where there's an unintentional act, that's not a wrongful death.
Where there's one?
That's not a wrongful death issue, there's an unintentional act. So the wrongful death statute lies with the parent.
Yes. Does that complete your question? Other questions to the patron on the bill? Hearing none, those who are here who would like to testify before the committee would be happy to hear your testimony. Again, we would ask you to be brief, concise, and try to be non-repetitive. And if you would come forward and identify yourself, if you're representing an organization or a group, that would be helpful for the committee to hear. Yes, ma'am. Please come forward.
Good morning. Louise Hartz of Henrico County and representing the Virginia Society of Human Rights. Modern medicine has already granted the unborn babies a unique form of personhood as treatable patients through various and successful surgeries on babies in utero. Thank you very much.
Thank you, ma'am. Others here who are speaking in support of the bill, please come forward. Seeing none, those who are here to speak in opposition, please come forward. Again, brief, concise, and non-repetitive. And please identify yourself.
Hi, Mr. Chairman and members of the committee. My name is Catherine Grenier, and I am the director of the Women's Rights Project at the American Civil Liberties Union of Virginia. To be brief, we are in opposition to this bill for the following reason. We believe that the bill would undermine the ability of women and their families to make personal and private decisions. We may not all agree about abortion or when life begins, but we hope that we can agree that this is a personal decision that should be made by a woman, her family, and her doctor, not the legislature. We have some concerns about the fact that this bill could be used to ban commonly used FDA-approved methods of birth control, including the pill and emergency contraception. We also are concerned over the bill's possibility for far-reaching, dangerous consequences on important life decisions that Virginians make every day. For example, giving legal status to fertilized eggs could block stem cell research from being used for life-saving care, could prevent couples from using in vitro fertilization to have a family, and could even deny a pregnant woman life-saving medical treatment from a disease like cancer if the treatment might harm a fertilized egg. We are worried over the possibility for this bill to endanger women's health and lives by interfering with doctors' ability to treat miscarriages and ectopic pregnancies. a woman experiencing a miscarriage or who has an ectopic pregnancy may need emergency treatment to prevent serious damage to her health or even save her life. But by granting legal status to a fertilized egg, the bill raises the specter that a doctor who provides the care the woman needs would be subject to criminal prosecution and civil suits. And I'll end by saying that this bill would lay a legal foundation to outlaw abortions in Virginia in the event of a reversal of current Supreme Court precedent, even for rape and incest victims, or when the life of the woman is at risk. Giving legal rights to fertilized eggs could impact literally thousands of laws as well, from when property rights are granted to inheritance rights or who can file a lawsuit. Would allow lawyers in the courts to reinterpret every Virginia law and regulation that contains the word person, which clogs up the court system at the expense of the Commonwealth's taxpayers.
Mr. Chairman.
Thank you.
Mr. Chairman.
I'm sorry, Senator Newman. Ma'am, would you take questions from a committee member?
Sure, of course, no problem.
Senator Newman.
Mr. Chairman, just one of the clarifications related to part of your testimony is regarding birth control and even emergency birth control. I'm sure you're aware, are you not, on the mode of operation of those products, is that correct?
Correct.
Mr. Chairman, further question.
Senator Newman.
Given the fact that both work as delaying or eliminating ovulation for the month, would you not agree that in birth control and even emergency birth control that there will not be conception, because if you don't have ovulation, you can't have conception?
That is certainly correct.
Thank you, Mr. Chairman.
Other witnesses who are here in opposition to Senate Bill 1378, please come forward and identify yourself.
Good morning, Mr. Chairman and members of the subcommittee. My name is Jessica Honke, and I'm the Director of Public Policy for Planned Parenthood Advocates of Virginia, and we're here to propose these bills today. I think the ACLU is absolutely giving some great examples of the consequences of what passing this bill will do in Virginia. So therefore, I will just limit my remarks to the fact that we oppose this bill. And healthcare decisions should be made between individuals, their doctors, and family, and free from government intrusion. Thank you very much.
Thank you for your testimony. Others here to speak in opposition to the bill.
Good morning, Mr. Chairman and members of the committee. My name is Tarina Keene. I'm the Executive Director of Me Around Pro-Choice Virginia. And again, I think that Kathy of the ACLU wrapped this up pretty nicely. We are opposing the bill, but I just want to point out that this really is an extreme bill. And when it's been brought up in other states, it has failed time and again. And when put to the voters, 77% voted down a personhood ballot initiative in Colorado in 2008. And in 2009, the North Dakota legislature considered the same type of bill, but it too was voted down. And Montana, Alabama, Maryland, and South Carolina have also made unsuccessful attempts. They voted down these measures not just because they are obviously unconstitutional, but most people do not support the contention that an embryo or a zygote is a person. Thank you so much.
Thank you.
Mr. Chairman, I have a question.
Ma'am, will you take a question?
Is any state adopted a bill similar to this, or a measure similar to this, either as a referenda or as a bill?
As far as I know, there's a policy statement that was made by the state of Missouri, but everywhere else in terms of legislation for ballot initiatives to change the Constitution, those have all failed.
Yeah, Mr. Chairman, when you say policy statement, that means it's not legislation. Is that what you're saying?
That's my
In
understanding.
Missouri, so there's no state that has adopted this as a law.
Yes, that's my understanding.
Thank you.
Others here to speak in opposition? Okay, Senator Stanley, we'll go back to you before we put the matter before the committee for action.
I may it please, with regard to Senator Edwards' question posed to the witness, Missouri has passed not a policy statement, but a law that was in 1986 that was also reviewed by the United States Supreme Court. The wording of that law was identical to the bill before you right now, Webster versus Reproductive Health Services, 492 U.S. 490, decided by the United States Supreme Court in 1989, upholding the efficacy of the law. It was upheld by the Supreme Court.
Mr. Chairman, is there any other state?
Senator Edwards.
Missouri that has adopted this as a policy or as a law? Any other state besides Missouri?
Senator Edwards, the only thing that I did when I did my research on this was grab the Webster case. So I can only speak to Missouri.
All right, thank you.
Senator Stanley, any other wrap-up you would like to give the committee before we put it to the committee for action?
No, Mr. Chairman, only that with regard to the witnesses who so kindly came up here and spoke in opposition to the bill, this is not a healthcare decision. This is just giving legal status. The ultimate effect of this is to create legal status for unborn in cases where there is wrongful deaths, most certainly. But thank you, Mr. Chairman.
Thank you, Senator. The bill is before the committee for action. What's your pleasure?
Move that the bill be reported. Substitute motion, Mr. Chairman.
All right, just a second. Was there a second to the motion to report?
Second.
It's been moved and seconded that the bill be reported. Senator Sansmal.
Substitute motion.
Is that bill be passed by indefinitely?
Is there a second?
Speaking to the motion, Mr. Chairman.
It's been moved and seconded that the bill be PBI. Senator Martin. On the motion for PBI.
I'm confident which way this will go. The committee is such that we've addressed these kinds of issues many times before, but I just want to observe, and in agreement with what Senator Stanley just said just a few moments ago, the language of this bill is clearly not addressing a health decision here. It is in fact determining whether or not the life of an unborn child is worthy of this protection or not. And so I would just want to make that observation, and of course I'm going to vote against the motion of PBI.
Further discussion on the motion to PBI? Hearing none, all those in favor of the motion to PBI signify by saying aye.
Aye.
All those opposed? Call the roll. The motion to PBI is approved on a 10-5 vote.
Thank you, Mr. Chairman.
Senator Stanley, thank you.
Thank you very much. Senate Bill 1207 is a bill that is based upon the Missouri statute that Senator Stanley discussed. This substitute reflects more accurately the Missouri law than I think the bill as originally drafted. It is the language that the United States Supreme Court approved in Webster versus Reproductive Health in 1989. We have been operating Missouri's been operating with this law and constitutionally applying it for 20 years. It is basically a civil counterpart to Lacey's law. We have passed on the policy here in Virginia several years ago, making criminal fetal homicide. We have criminalized fetal homicide, yet in Virginia we do not have a civil cause of action for the same conduct that we are able to send somebody to prison over. This would really have the impact of creating a civil cause of action for fetal homicide and for wrongful death for an unborn child. It does not. What it does not do is it does not change the law with respect to abortion. It does not change the law with respect to anything that is presently legal. It has very limited impact, and Mr. Chairman, that is what this bill does. And I do have a couple of witnesses that got up very early this morning to travel here, and if the committee would consent to hear brief testimony, I'd be grateful.
We will hear the witnesses in due time with some parameters, but at this point, let me ask the committee if they have any questions to the patron on the substitute that we've adopted. Questions to the patron. Senator Quayle.
Senator Virginia, I'm having the same problem with your bill that I have with Senator Smith's bill. I'm not exactly sure what you're trying to get at. I mean, I understand the words, but I'm not exactly sure the practical implications of this bill. And why don't you
Sure.
explain that?
Very simply, right now, we can send somebody to prison for fetal homicide. But a plaintiff, a mother or a father who lose an unborn child do not have a cause of action for wrongful death or the death of that unborn child. This law will create that cause of action for wrongful death for that unborn child. If you look at paragraphs 2 and 3 in this, that is the impact and effect of, that is the primary present-day impact and effect of this law.
Senator, does that complete your question? Senator Newman.
Mr. Chairman, Mark, my questions are along the same lines. You cited the Supreme Court case, and to me this looks more like a cause of action courts bill, if ever there was one, more than a health bill. But what did the Supreme Court say, and how did they rule in that case?
What the Supreme Court ruled was that this language does not unconstitutionally infringe upon the right of a woman to have an abortion, because that question is not right under this. It does not affect the constitutionality or the right of a woman as under the laws as interpreted by the United States Supreme Court to have an abortion. What the court did approve, the court found that narrowly confined in that fashion, that the law is constitutional.
Mr. Chairman,
Senator Newman.
not being in courts and not being a lawyer, what are the parameters of the recovery? In other words, what are the expectations on the recovery? Let's say that you were successful. Is it anticipated that it would be a monetary recovery? And if so, what are those limits?
Well, there are no limits. We don't have limits in personal injury cases. As Senator from Roanoke, who is an experienced litigator, would likely explain that the discretion is left to, and the limits are left to the discretion of jurors. We have Seventh Amendment right to trial by jury, which we trust just as much as any other constitutional protection.
Mr. Chairman,
Senator Edwards.
you say one of the purposes of this would be to give the parents the right to bring a cause of action on behalf of the unborn child.
Well,
And is that right?
well, it's a wrongful death action. The wrongful death action would reside with the parents.
Right.
It's not, it would be defined by a wrongful death statute.
Mr. Chairman,
Senator Edwards.
but in those cases, the mother would be injured. And in the case of where a mother is injured, she could bring her own cause of action, and part of the damages would be the loss of the pregnancy. Would you not agree?
I would not, well, I would agree that the mother has a personal injury action for her physical injuries. She does not have a wrongful death action for the loss of the
Mr. Chairman.
child.
Mr. Chairman,
Senator Edwards, further questions?
Yes.
We're not going to get into a running debate. Well, this is point to have questions to the patron on this bill. Senator Edwards.
granted, wrongful death is a separate cause of action by statute, but the personal injury actions the mother has, in the context of that personal injury action, all the damages to her, including the loss of the pregnancy, could be presented to the jury. Do you not agree?
I would not, I would agree to the end, and I hope this means I'm persuading Senator Roanoke because as the Senator knows, the elements of damage for wrongful death are statutorily laid out, and there is no ability to recover for wrongful death of the child, which is a very different injury than the physical injury to the mother.
So, Mr. Chairman, to follow up,
Senator Edwards.
but the jury would have all the information about the death or the loss of the pregnancy, and all that information could be presented to the jury for the jury to make a determination as to the damages to the mother. Would you not agree?
Well, I would not agree because, I mean, you and I have argued these issues to judges many times, and we are forced to assume that juries are going to follow the law with respect to the elements of damage. We can hope as trial lawyers that we can cause a jury to consider other things and to make a damage determination on the basis of sympathy or hope that they will award damages for the death of the unborn child. But the fact of the matter is, we adhere to that legal, I prefer not to believe that it's a legal fiction. I believe that it's true, that jurors do work hard to try and adhere to the instructions that they're given. And I don't want to have to rely, and I don't believe that we as attorneys should rely on the hope that a jury is going to look outside of the instructions and say, hey, even though I'm not allowed to compensate this mother for wrongful death for the death of the child, we're going to, with a wink and a nod, do it anyway. I mean, that's not the way that our system is designed, and I don't believe that that happens with regularity.
Thank you. Okay, with the point to hear testimony on the bill on behalf, the chair is going to set some parameter.
That's fine.
The chair will observe that this bill principally is the same as Senator Stanley's bill, by my estimation. So I would ask that those witnesses who may have something to add beyond what we've already heard on Senator Stanley's bill, if you would share with us. We certainly want to hear from the witnesses. I don't know that we need to repeat all the testimony, all the witnesses we've already heard, but something different.
You could afford Ms. Dunaway
Sure.
from the Rutherford Institute about 3 minutes.
We're going to provide time for those who maybe have not testified on Senator Stanley's bill. We're pleased to have you with us.
Thank you. Good morning. My name is Rita Dunaway. I am an attorney with the Rutherford Institute, and I have worked with Senator Obenshain in developing this bill. I'd like to present a statement by John Whitehead, president of the Rutherford Institute, in favor of the bill. The Rutherford Institute supports the bill as an important declaration of policy that the weakest and most vulnerable members of the human family possess human rights deserving of protection. The bill creates a tangible means of protecting these rights by allowing parents, and I would say not only mothers, but fathers as well, to bring a civil cause of action for the wrongful death of their unborn child. The bill would thus render Virginia's civil law consistent with that of the majority of states which already recognize this cause of action, and with its own criminal law, which recognizes fetal homicide as a crime. This legislation is not unprecedented, having been in effect in Missouri for over 20 years now. The United States Supreme Court refused to entertain legal challenge to that law in the Webster case, ruling that the statute can be interpreted as properly expressing a policy judgment favoring childbirth over abortion, and deeming conception to be the point at which legally protectable interest accrues. Without this kind of legislative action, courts are left to their own devices in defining the contours of legal personhood. And courts then retain the prerogative to exclude weak, disfavored, or disabled members of the human family from the enjoyment of basic human rights. Given the remarkable advances in science and technology in recent years, it is proper for the legislature to declare the legal meaning and scope of state rights and to remove the temptation for judges or other authorities to apply the law in ways that abrogate fundamental rights of the politically weak or disfavored. And in closing, I would just encourage you members of the committee not to accept the specious allegations that I've heard from the other side that this bill would interfere with lawful practices such as contraception or in vitro fertilization. That is not the case. And the clearest evidence of that is the fact that, again, this law has been in effect in Missouri for over 20 years. And all of those practices have continued uninterrupted. Thank you. I'd be happy to take any questions.
Thank you, ma'am. Others who are here that we have not, let me just make it clearer, because I just had a little sidebar up here with the patron. It would be the chair's intent, since we heard Senator Stanley's bill thoroughly, that if there's witnesses that we have not heard on Senator Stanley's bill, we're going to take the opportunity to hear from them. But the chair is going to observe we're not going to just go through the entire repetition of all those witnesses that we
chooses
to carry her unborn child to term an additional ability for civil action if something happens to that unborn child. We claim that we support a woman's right to choose in Virginia, and yet, when she chooses to carry her unborn child to term, we don't want to give her the same opportunity as others. And all this does is say if you choose to carry your unborn child, then you're going to have this additional ability for civil action.
Mr. Chairman,
Thank you. Senator Whipple.
could you speak to paragraph 4 of the bill and make sure that that's all visible?
Will the witness take a question?
Sure.
I would note that not this witness's bill, and if he can answer it, fine, I'd be happy to address it too.
Mr. Chairman, my concern was the word all.
Sorry.
All, excuse me.
I'm sorry. You said that the only thing all this bill does is, I think, represented in paragraphs 1, 2, and 3.
So
I would think if you went on to paragraph 4, you would find that it did more than the specific point you were addressing.
Correct.
Thank you.
Thank you. Other witnesses who have not been heard on Senator Stanley's bill, please come forward. Those who are in support of the bill.
Jeff Caruso with the Virginia Catholic Conference, we support this bill. It would further the understanding of the Commonwealth about the sanctity of human life from conception onward, and also the understanding that a natural right to life exists. Thank you.
Others who we have not heard from in support of the bill. We'll hear from those in opposition who we have not heard from on the previous bill. If there's any information we have not had, now I just got the other side, set the ground rules, anyone we have not heard from. And I think that was pretty clear. Anyone who is in opposition that we have not heard from on the previous bill. Senator, I'll give you the opportunity to wrap it up.
Very briefly, Mr. Chairman, members of the committee, this treads no new ground for this body. It simply conforms our civil remedies to criminal laws that we have passed out of this General Assembly. And accordingly, I would hope it would be the pleasure of this committee to support this bill.
Senator Newman.
Mr. Chairman, if it's appropriate, just a question. We've talked back and forth, but it brings up a large question that on how it works I'd like to ask, and that is, Mark, if the bill passed, and if you had a woman that was pregnant, that was poisoned or something of that nature, the child as a result of that dies and there's a miscarriage, and the mother had uncomfort but lived. Under the current law, you could have a cause of action against the individual who did the poison beyond criminal that would possibly be recoverable, but the effect on the child or the life of the child would not be included under current tort law, and under this it would. Is that correct?
There are elements that are recoverable in a personal injury case, like pain and suffering, medical bills, the likes. What is not recoverable in a personal injury action that is recoverable in a wrongful death action are things like solace and loss of companionship. Now, granted, with a young child, I mean, we lawyers sometimes have a difficult time not being cynical, but the difficulty with a young child, and undoubtedly with an unborn child, is how do you value loss of companionship with that unborn child? But that is what the jury system is about. We ask a jury of our peers to make those determinations, not us.
Second, please, your question. Mr. Chairman, the bill is before the committee for response.
The substitute motion is to pass the bill by indefinitely.
Is there a second?
Mr. Chairman, speaking to the motion,
Is there discussion? Is there discussion on the motion? Senator Edwards.
If we PBI Senator Stanley's bill, I don't see any real difference between that bill and this one. I've looked at it carefully. You've added some first 3 paragraphs that don't say anything particularly, or don't change anything. On paragraphs, line 15 through 17, you kind of reworded it, but it basically says the same thing. I don't really see any difference between the 2 bills. Tell me about the PBI.
Any other discussion? Signify by saying aye.
Aye.
All those opposed?
No.
10 yeas, 5 nays.
10 yeas, 5 nays, the bill is PBI, Senator. You have another bill, I believe, on the docket.